And welcome to this. They're now recording me, so I'll start again. A very good morning, everybody, and welcome to this panel session, Routes to Resolution. My name is David Steward. I'm the President of the London Maritime Arbitrators Association. Now, we're going to be taking questions at the end of the session, so please feel free to submit your questions using the chat box, and I'll have a look through those and we'll raise them with the panellists later on. Now, unfortunately, Lord Wolfson can't be here to give his opening comments, but we do have our expert panel with us, and we're going to be discussing this morning the use of London arbitration in resolving maritime disputes. The title of our session, Routes to Resolution, reflects the aim of London maritime arbitration, which is to provide people in the industry with a service that helps them to resolve their disputes cost effectively, commercially, and in accordance with the law. And we'll be sharing our experience this morning to give you guidance on how best to use arbitration for that purpose. Now, we're in the heart of international dispute resolution here in the brand new IDRC building near St Paul's Cathedral in the City of London. And we're enormously grateful to the team here for hosting us in this wonderful venue today. You can see the weather outside the window is not great, but there's not much we can do about that. It's still a very comfortable and pleasant place to be. And I'd like to start by introducing you to the founder of the IDRC and its current Chief Executive Officer, Damien Hickman.
Thank you, David, gentlemen. Again, yes, just a welcome to the IDRC, and hopefully it'll be in person. We've got another event going on downstairs where we've got 100 people actually arriving in person. So things are actually coming back to in-person events. One thing we did at the new IDRC, we've had this innovative air conditioning system put in, which eliminates 99.9% of viruses, allergens, bacteria. So really trying to make a safe environment for people to actually come back and host their disputes. As David said, we've just moved to a brand new building. This is our second day. So a couple of little teething problems here and there, but it's all going well. David said we're near St Paul's Cathedral. The other side of these trees is the front of St Paul's Cathedral. So in the winter, you just see the front of St Paul's Cathedral. So the IDRC, we set the IDRC up over sort of 20 years ago. With the new building here, we have 18 hearing rooms, so we can do 18 hearings a day. And also what we've done at the new centre is we've made it a real hub. So we've got a lot of institutions that are based here, a lot of other people involved with ADR. So we have the likes of CEDA, LMAA, LCIA, sports resolutions, IPOS mediation companies as well. So what we've done is made it a real hub for London, so people can actually hold their disputes.
Excellent. Thank you very much, Damien. Now, on to the meat of the session. My first question is for Karen Maxwell. Karen is a barrister practicing at 20 Essex in London, specialising in commercial law and international trade, with a particular focus on arbitration and maritime cases. And Karen is the co-author of the leading textbook on London maritime arbitration, the fourth edition of which was published in 2017. Karen, can you set the scene for us, please, by telling us how maritime arbitration law and practice have evolved in London over the years?
Good morning, everyone. Can I start by thanking you for inviting me to join you today? I'm sure we're going to have some very interesting discussions. Well, we have a very well-established tradition of arbitration in this jurisdiction. There has been an Arbitration Act on the statute books since the late 17th century, and maritime arbitration in London goes back hundreds of years. So I guess the starting point is to say that the various mechanisms and procedures that we're all so familiar with, they are part of a system of law that is well developed and mature. That's not to say, of course, that arbitration law doesn't continue to evolve, and it very much does. And I think maybe the best way I can answer your question is by identifying a couple of recent trends that certainly I've noticed. I think the first one that I would pick out is a trend that I think goes back to the Arbitration Act coming into force. The Arbitration Act came into force at the beginning of 1997. It's the 25-year anniversary of the Act this year, and it provides a framework for the support of arbitration within this jurisdiction. And I think one trend that we have noted since the Act came into force is a reduction in challenges to awards. We know from the statistics that the Commercial Court produce from time to time that the number of challenges is on a gentle downward trajectory. Certainly the number of successful challenges is, I think I would say, on a slightly steeper downward trajectory. I think that's particularly striking because, of course, arbitration is increasingly popular. Certainly in London, we know from the various published statistics that arbitration is on an upward trend. Of course, there are yearly fluctuations, but if you step back, you can see that the trend is upwards. And certainly last year, I know the LMAA saw a year-on-year increase, as I think did the LCIA. So the position is we have an increasing number of arbitrations, but a decreasing number of award challenges. And I think if you sort of try to think about why that might be, it reflects the principles that underlie the Act, and in particular, the principle of party autonomy and the idea that the courts want to support an arbitration, but not to interfere in the result of an arbitration. And I think those principles are now well understood by parties, and they're certainly applied rigorously by the courts. I think more generally, looking at procedure within an arbitration, for those of us involved in maritime arbitration, many of the changes that we see have been embodied in amendments to the LMAA rules. So there is a group within the LMAA. At the moment, it's led by David Owen QC, and they take feedback from users of London maritime arbitration. And I've certainly heard David say that he welcomes feedback from people who are involved in arbitration. And in the light of the feedback, the LMAA will tweak their terms from time to time to reflect the needs of users. So it tends to happen roughly every 5 years or so. And usually the changes that are introduced are with a view to enhancing the effectiveness or the efficiency of arbitration. So to just give you a couple of examples, LMAA questionnaires, these are the documents where the parties set out the various issues that arise and what's required in terms of procedure and evidence. And they were introduced in the early 2000s with a view really to streamlining procedure and to make sure that the parties can pick their way through the procedure as efficiently as possible. A more recent example would be the changes to the rules governing witness evidence, and they are contained in the 2021 terms, and they're very much inspired by new court rules that were brought in to try to bring factual witness evidence back within its proper scope. And just to give you a broad overview, I think there was a concern that really witness statements were being used as a medium for arguing rather than for giving factual evidence. And of course, that's both not a proper use of witness evidence, but it's also very wasteful. So the LMAA have taken steps sort of in tandem with the courts to try to bring that back within proper limits. I think finally, from a procedural point of view, when you look back at the period, since the Act came into force, the really big story from my point of view has been the importance of technology. And you can see that at all stages of an arbitration. So a contract is now likely to be concluded by email or perhaps by electronic messaging. And many of the documents that fall to be disclosed will be electronic documents. And that means that electronic disclosure is now the norm. We also see that some aspects of claims can be dealt with by use of software or spreadsheets. So things like speed and consumption claims, perhaps demurrage claims. These used to be the sort of claims that would be dealt with by very junior barristers or solicitors. They've now pretty well been automated and are dealt with electronically. When it comes to hearings, of course, 2020 was the year that we all had to get used to virtual hearings. The LMAA were pretty quick off the mark, actually, and I think the maritime sector did lead the way here. And they were very quick to set out some guidelines for virtual hearings, and those are now incorporated in the 2021 terms. And we mustn't, of course, forget the courts, because the courts and arbitration do work in partnership in this jurisdiction. And so the commercial courts were also very quick to bring in virtual hearings. And so it was pretty well business as usual in court as well. And I think the really interesting question looking forward is whether we are going to continue using virtual hearings, and if so, for what purposes, once the pandemic has receded. I don't know if any of you have looked at the recent Queen Mary White and Case survey, but they looked at this question, and it does seem that there is an appetite among parties for the continued use of virtual hearings, particularly for procedural hearings. So that will be an interesting one to watch, I think, going forward. So I guess just to sum up, I mean, the basic building blocks of arbitration law are very much in place and have been for many years, but it is, I would say, a constant process of evolution.
That's extremely helpful. Thank you, Karen. That's given us a very good context for our discussion this morning. And just to add one point, one of our main sources for feedback when we're reviewing the LMAA terms is the groups of supporting members. We have supporting members in the Asia-Pacific region and supporting members elsewhere. And we meet at least twice a year with the supporting members to take feedback. And certainly that's one of the routes by which we get guidance on where tweaks and changes might be required. Thank you, Karen. Now, Sir Nigel Teare was formerly the Admiralty Judge and also Judge in charge of the Queen's Bench Division. And he retired from the bench a year ago and is now a full-time arbitrator with Arbitrators at 10 Fleet Street. Nigel, can you tell us, please, about something which Karen touched on, which is the relationship between arbitration and the English courts, and in particularly the use of applications in aid of arbitration?
Thank you very much, David. If one had to use one word to describe the role of the court with regard to arbitration, it is support. That is support for the process of arbitration. The Arbitration Act of 1996 is based upon the principle that parties should be free to agree how their disputes are resolved, and that the court should not intervene except as provided by the Act. Where parties have chosen the process of arbitration rather than litigation, the commercial court seeks to assist and support the process of consensual arbitration. And I can mention just a few very obvious examples of this. Where court proceedings are brought in England in breach of an agreement to arbitrate, the court can order a stay of those proceedings. And where foreign court proceedings are brought in breach of an agreement to arbitrate, the court can issue an injunction restraining the claimant from pursuing those proceedings. Where the appointment procedure has failed, the court has power to resolve the difficulty or to make the necessary appointment itself. The court may make an order that a party comply with a peremptory order of an arbitration tribunal. And in cases of urgency, typically before an arbitration tribunal has been formed, the court can make orders for the preservation of evidence so that it will be available at the hearing of the arbitration, or of assets so as to minimize the risk that an award may not be enforceable. And finally, of course, where an award has been made, the court can assist in ensuring its enforcement by permitting it to be enforced in the same manner as a judgment of the court. And those, David, are the principal examples of the support that the court gives.
So, thank you, Nigel. That's very helpful. What about, is there anything you'd like to add about intervention by the courts in arbitration?
Well, intervention in the arbitration can, of course, take place, but most examples of intervention require the consent of the parties or of the arbitration tribunal. So where there is a dispute as to whether a claim falls within the jurisdiction of the tribunal, the court may determine the jurisdiction of the arbitration tribunal, but only if the parties agree or the application to the court is made with the permission of the tribunal. The court may also make orders for the preservation of evidence or of assets, even where there is no urgency, so long as the application is made with the permission of the tribunal or the agreement of the parties. And an important preliminary point of law may arise in the course of an arbitration. The court may determine that preliminary point of law, but again, only with the consent of the parties or the permission of the tribunal. Because of the need for consent, such instances cannot, in my view, be regarded as intervention in the process of arbitration, but as examples of the court assisting the parties or the tribunal when requested to do so. But there are, of course, other opportunities for intervention by the court which do not depend upon consent, but they are strictly limited and exist for good reason. For example, where there is an agreed time limit for the commencement of arbitration, the court may extend the time for commencing the arbitration proceedings, but only where the circumstances are such as were outside the reasonable contemplation of the parties when they agreed the time limit, or where the conduct of one party makes it unjust to hold the other party to the strict time limit. The court may also remove an arbitrator if there are justifiable doubts as to his impartiality, his qualifications, or his physical or mental capacity to conduct proceedings, or where the arbitrator has failed to conduct the proceedings properly or with reasonable dispatch. Although they can be described as examples of intervention by the court, not dependent upon consent, they may also be viewed as powers which are necessary to support the process of arbitration. There are, of course, other well-known examples of intervention in the arbitration process. They are permitted by sections 67 and 68 of the Arbitration Act. They are perhaps more controversial because they can be viewed as an interference with party autonomy. However, the justification for them is that they are judged to be in the public interest. Section 1 of the Act describes them as safeguards that are necessary in the public interest. Let me say just a little about Section 67 is an alleged failure by the tribunal to comply with its duty under Section 33 to act fairly. This opportunity to challenge an award is frequently seized upon by a losing party, but as Karen Maxwell has said, it rarely succeeds. Case law has established that a balance has to be drawn between the need for finality of the award and the need to protect parties against the unfair conduct of the arbitration. In striking this balance, only an extreme case will justify the court's intervention. Relief under Section 68 will only be appropriate where the tribunal has gone so wrong in its conduct of the arbitration and where its conduct is so far removed from what could reasonably be expected from the arbitral process that justice cries out for it to be corrected. That is a very high hurdle to surmount and explains why the court will not intervene, save in very rare cases where something has gone very badly wrong. Losing parties are often disappointed by the tribunal's decision on important issues of fact. They often say that the tribunal has failed to give effect to a particular piece of evidence. But this cannot amount to a serious irregularity. Section 68 is not about whether the tribunal reached the right answer on the evidence before it. Were it otherwise, the courts would find themselves reviewing the evidence before the tribunal to see whether a particular finding was justified or not. And that the court cannot do because the parties have chosen their own fact finder, and that is not the court. It is for the arbitration tribunal to decide what evidence is relevant and what it accepts. I would therefore suggest that Section 68 provides for the intervention of the court in extreme cases only. It exists in the public interest and should not be regarded as an unjustified interference in the process of arbitration by the court.
Thank you very much, Nigel. I gather we lost Nigel very briefly during that session, and I apologise for that. And if anybody does have any questions arising out of what Nigel was saying, please do put them into the chat box. Well, having set the scene and described the current position on arbitration and the relationship with the courts, let's now take a look at this from a user's perspective. Now, Nicholas Wu is a partner in the law firm Birketts, and he heads their shipping and international trade team. Originally from Singapore, Nick is a dual qualified lawyer, both there and in England. And he also has commercial experience, having worked in-house for the Singapore subsidiary of a major Chinese shipping company. Nick, in your experience, how can users make best use of maritime arbitration?
Thank you, David. I think the first point I want to make is that London arbitration is a very open forum. By open forum, I mean that it is very welcoming and non-exclusive. So, for example, I know that some jurisdictions used to have problems with foreign lawyers representing clients in their arbitrations, and that is much less so. London never did. So a foreign lawyer, if he or she feels confident enough about English law to argue that case for his client, is always welcome in London arbitration. And obviously, as an English solicitor, that isn't good for my business. But I would say that the market has shown that the English solicitor working with the barrister is an optimal relationship in terms of representing a shipping client on English shipping law disputes. But leaving that aside, we then come to the question of choosing arbitrators. And again, that is also very open. Of course, it's subject to the terms of the clause. Some clauses say that arbitrators must be members of the LMAA. But the LMAA itself, in a sign of openness, has, in the last few years, clarified that includes supporting members. So the full membership list is about 30, 40 strong.
37 full members, I think, is the current number, but in total, we have something like 800 members, including aspiring full members and supporting members.
There you go. So LMAA shall be members of the LMAA has been interpreted by the LMAA to mean anybody who is a member, supporting or full. So that's another sign of openness. But I guess the next question is, what does a user look for in choosing an arbitrator? Clearly, it seems to me obvious that in shipping, you want to choose an arbitrator who knows shipping. No point in choosing an arbitrator who knows sports law in a shipping dispute. But even within the topic of shipping, there are certain arbitrators who have particular areas of expertise. Former engineers, for example, will maybe, I say not will be, but maybe more suited to hear disputes in respect of maintenance of engines and engine breakdowns. Some arbitrators I know enjoy speed and consumption disputes. And for those of you who are listening here, may share a wry smile about speed and consumption. And Karen mentioned spreadsheets, and if only, speed and consumption can still be difficult to follow, shall we say. It's not actually a complicated subject, but it can be. Looking at reams of numbers, you ask a lawyer to look at reams of numbers, and more often than not, he or she ends up falling asleep. But some lawyers are very good at that, and ditto some arbitrators. I think the most important quality for an arbitrator is being fair, just, to act like a judge. An arbitrator who is biased, implicitly biased, does no good for anybody, least of all his so-called clients. Again, I know some people have the impression that the arbitrator is my person because I appointed the arbitrator. And I've often reminded clients that no, a London arbitrator, the best London arbitrator is the one who is above all impartial. And I think that has been the quality of London arbitrations, and particularly LMAA arbitrations. Efficiency, obviously, being able to respond quickly to the parties' requests for applications. And last but not least, speed in writing awards. I am unfortunately old enough to remember the bad old days when sometimes it could take 6 months for a tribunal to write an award. That, I'm very glad to say, is a thing of the past. And an LMAA arbitration, you normally normally get an award within 3 to 4 weeks of the close of hearings. So that has been a marked improvement and a forward-looking thing too. Also, of course, in terms of the profile of arbitrators, that has also changed considerably, particularly the number of lady arbitrators. That has improved a lot, and that is, again, to be much welcomed to give a better balance. We have the usual mix of commercial as well as legal people on the panel, and indeed supporting members. So again, you have a wide variety to choose from. I'd like to move on to touch on a topic that Karen mentioned, which is the future of London arbitration. And obviously, the pandemic changed everybody's lives, and not least London arbitration. I just share with you two maybe 3 points. The first is that although this concept of virtual arbitration, or the term virtual arbitration, is a fairly recent one, in fact, London has been running virtual arbitrations for years, but under the radar, in a sense, with not much publicity, I suppose. You will see this in the statistics. David will correct me, but of the 300, 400 awards that the LMAA publishes every year, you will notice that only 80 to 100 are written pursuant to a hearing, which then begs the question, what about the other 200 odd? And the answer is that the other 200 odd are written pursuant to a documents-only arbitration hearing. Now, this has been a feature of London arbitration for many years. So London has been at the forefront of virtual hearings. It's not a new thing to us. The second story I wanted to share was, this was something that happened to me about 10 over years ago. I was just sharing with my two colleagues here just now that I arrested a vessel, shame on me, on Christmas Eve. Even worse, shame on me. But it wasn't my fault because the ship arrived on Christmas Eve. But anyway, the other side, not surprisingly, was very angry, but more surprisingly, applied to the tribunal to set aside my arrest and asked for an urgent hearing to do so, given the holiday season. The tribunal obliged and said, well, obviously it's Christmas Eve now, let's be realistic. But the tribunal said, we will hear you on Boxing Day, and we will hear you by email. So everybody sits down at the terminal. The applicant opened by making his submissions by email to the tribunal. I was the respondent. I replied by email. The applicant had final word by email. We then adjourned and stood by our terminals. And half an hour later, the tribunal made its decision and dismissed the application, I'm very happy to say. So this is a story of 10 over years ago and an example of a virtual hearing 10 years ago. So as I said, nothing new. The third story I wanted to share is a recent one where I've just completed a 6-day virtual arbitration. This was in May, so before the end of lockdown. Parties, my clients, in fact, everybody was in Asia, including the witnesses as well as the experts. Most of the experts were in Asia. We had a 3-person tribunal, all seated at home. Both counsels seated at home, both barristers seated at home. Probably we had up to bundle K. So, count six documents, bundles, over 1,000 pages. All handled smoothly. IDRC was very great help in setting up the virtual Zoom provisions. Another company then worked with IDRC to make sure that the documentation was all neatly in place with bundles and numbers and cross-referencing. And with the Zoom function, as you all know, it was just a simple thing, and the rest was just hearing procedure. Nothing was lost at all by having the hearing heard virtually. People talk about nuance and witnesses, but most of the time in a shipping arbitration anyway, unless you have a terrible dispute of facts, most of the time it's expert evidence questions. And so playing to an audience or trying to see whether somebody's lying or not doesn't really matter. In any event, the video camera is very clear. So the picture is very clear. You can see shifts in body languages very easily. You can follow the judge's pen. In this case, obviously the arbitrator's pen. Seeing whether the arbitrator is interested in a particular point or not. All the same advantages that you have in a real hearing were present in a virtual hearing. So it was very successful, and certainly has made me a fan of virtual hearings. And again, this is something that London doesn't find at all unusual or difficult to use.
Thank you very much, Nick. I need to just take a very short break for a technical issue, because when the system dropped a little while ago, the Q&A window disappeared from my laptop, and I've just wondered, Duncan, whether someone could restore that for me, please. Apologies, everybody. Well, thank you to Nick for that review. It's extremely helpful. I would just like to add that I have done a number of virtual hearings, and I sat on one last November where, although one of the parties was uncomfortable about the idea, we managed to secure agreement of the parties that we should proceed on a virtual basis. And it has to be said that if we hadn't done that, then the case would still be unresolved. We'd still be waiting for an opportunity to get everybody together. And so it really is important, I think, that we buy into the idea of virtual hearings, as we have done, to ensure that justice is not delayed. Now, I'd like to come back to Karen. Karen, you mentioned that maritime arbitration is commonly governed by the Arbitration Act and the LMAA terms, and the object is cost-effective and timely resolution of disputes. Could you describe for us briefly, please, how the Act and the terms enable and require both the parties and the arbitrators to achieve that object?
Yeah. So the Act is a framework. It's not intended to be an exhaustive code. So it leaves space for the parties to agree the terms that they would like to apply. And of course, insofar as they've agreed to apply, for example, the LMAA terms, there will be provisions contained within the terms that are very much angled towards achieving efficiency and speed. And as I'm sure we're all aware, there are various sets of terms, for example, the small claims procedure to deal with the needs of particular types of dispute. So it's always open to the parties to agree whatever terms they would like. But if we put that on one side for now, even just taking the Act standing alone, it does provide, I think, quite a good framework. And it's been designed with a view to achieving efficiency. And it does that really in three ways. So the first technique that's used is, as Nigel Teare mentioned earlier, Section 1 sets out the general principles on which arbitration is founded. And one of them is that arbitration is to be conducted without unnecessary delay and expense. That's quite unusual, actually, for English legislation, but the courts do refer to the general principles when interpreting the Act, and arbitrators tend to refer to them as well when they are making procedural directions, for example. And actually, the Departmental Advisory Committee that drafted the Act, their comment was that an arbitration that doesn't adhere to the basic principles can't really be described as an arbitration. So it's absolutely fundamental and forms part of the definition of an arbitration. So that's, if you like, the sort of base layer of protection. The second technique that's used in the Act is to impose duties on the tribunal and the parties. And I think we've mentioned the Section 33 duty that's placed on a tribunal. And that duty includes a duty to proceed efficiently and with a view to minimising expense. I think what's often forgotten, though, is that parties are also under a similar duty, and that's imposed by Section 40. So everybody involved in the arbitration, if you like, by choosing arbitration in this jurisdiction, they've signed up to these duties. The third technique that's used is to provide remedies for the case where a duty is breached or where there's a danger of breach. So, of course, the tribunal can always make directions, can make orders on costs to try and push things along, or to reflect conduct of an arbitration that hasn't perhaps been cost effective. There are also powers under Section 41 for dismissing a claim where there has been inordinate and inexcusable delay, and the tribunal can make peremptory orders requiring the parties to act, and those are actually enforceable by the court. And as Nigel Teare explained earlier, in a very extreme case, you can challenge an award under Section 68 if there's been a breach of Section 33, or perhaps remove an arbitrator. But thankfully, those are only for very extreme cases, and in practice, it's very rare. So there are remedies there. I think my own view is that this is one area where some improvement to the law could be made, in the sense that I think many arbitrators feel that they would like additional remedies or tools that would allow them to push an arbitration along more effectively, where the parties aren't doing that themselves. So, for example, there is no specific remedy for breach of the Section 40 duty that's placed on the parties. That's just one example. So my own view is that that's one area where, improvements could be made. But in general, I think the system works well, and I think the combination of the Act, and certainly where you've got the LMAA terms in conjunction with the Act, you've got a really good framework there for achieving an efficient arbitration.
Excellent. Thank you, Karen. That's very helpful. Nigel, I'd like to just come back to the question now of appeal against arbitration awards. Users like the finality of arbitration because they like to feel they're getting their disputes resolved, understandably. But they also want to be reassured that decisions are right in law. So there's a balance to be struck. Do you think the current law and practice in England strike the right balance in that respect, or should the balance shift?
Well, the balance is provided by Section 69 of the Arbitration Act. That is the section which provides for an appeal on a point of law. It's important to bear in mind that it can be excluded by the parties. Where it has not been excluded, a losing party needs to obtain the leave of the court. And leave is only given if the point of law substantially affects the rights of the parties, and either the tribunal's decision was obviously wrong, or the point of law is of general public importance and the decision of the tribunal is at least open to serious doubt. In this way, the opportunity to appeal is limited to those cases where it is indeed in the public interest for the appeal to go ahead. Where those conditions are not satisfied, the arbitration award is final. And that will be particularly so where there is an issue as to the construction of a one-off contract, which is not a standard form, unless the tribunal's decision can be said to be obviously wrong, in which case leave to appeal can be given. And that is how the balance between finality and correctness in law is achieved under the Act. Now, in some areas of commercial dispute resolution, this opportunity to appeal on a point of law is frowned upon as an interference with party autonomy. That is, the party's right to choose the tribunal, which is to determine their dispute. But as I've already noted, the opportunity to appeal can be excluded by the parties, and certain standard forms of arbitration clause do so. So again, it is difficult to describe a Section 69 appeal as being brought contrary to the agreement of the parties. In the world of shipping, it is not often excluded. Indeed, the courts are now seeing contracts which expressly provide for a right of appeal to the court on a point of law. The benefit of a right of appeal, or the opportunity to appeal pursuant to Section 69, is that it assists English maritime law, as recorded in public decisions of the Commercial Court, to keep up to date with modern trading conditions and with developments in the operations of ships. Thus, Section 69 and the balance it strikes between finality and correctness in law is, I think, in the interests of the shipping community, and in particular in the interests of those who arbitrate their disputes in London.
Thank you, Nigel. Karen, can you tell us, please, about the enforcement of London arbitration awards, and in particular, whether enforcement has been affected by Brexit?
Yeah, well, I mean, the short answer is that it hasn't been affected by Brexit, and Brexit is not relevant. So arbitration awards are enforced under the New York Convention. That's a highly effective and very well established mechanism for enforcement of arbitration awards. And most jurisdictions worldwide have signed up to it. And indeed, I think for many parties, one of the most significant advantages of arbitrating rather than litigating is ease of enforcement. So enforcement under the New York Convention is not affected by Brexit. Arbitration has always been outside the scope of EU legislation. So think about the Brussels regulation and the arbitration exception. A country's obligations under the New York Convention are entirely unaffected by the question of whether or not they're a member of the EU. So that's the position as a matter of law. I mean, I think it's fair to point out that some people, in fact, many people, I think, were worried that even though Brexit is legally irrelevant to enforcement, that there was a concern, I think, that it might affect the reputation of London. You know, would people see us as being very inward-looking or parochial? That's a description that certainly many of us would consider to be very unfair, but that was certainly the concern. And again, the Queen Mary survey recently has looked at this question, and the authors of that survey have come to the conclusion that the popularity of arbitration in London has not been affected by Brexit. So even on a sort of question of impression, it seems that Brexit has not affected the position, and it's certainly not relevant to the enforcement of awards.
Thank you, Karen. And I would echo something that Nick said about this being a welcoming forum. From our perspective, we see our role in providing a service as providing independent and unbiased arbitration for people all over the world. So it is very much in our blood that we function in that way. And it's certainly not inward looking. Yeah. Karen, one of the questions that appeared in the Q&A box is in relation to review of the Arbitration Act. Now, it's the 25th anniversary this year of the Arbitration Act 1996. Are there any potential areas for review?
Yeah, so people are talking about this quite a lot at the moment because, of course, the Law Commission have just closed a consultation on the question of whether we should look at reviewing the Act. And I think many people involved in London maritime arbitration feel that the Act is working well, arbitration's very popular. So, you know, why would you start tinkering around with the legislative provisions? And I do have some sympathy with that view. And of course, care is necessary to ensure that we don't damage a system that is working well. But we have to, I think, acknowledge that London is competing with other arbitration seats. And again, if you look at the statistics gathered in the recent Queen Mary survey, we see that for the first time, London has tied with Singapore for first place, having in previous surveys been quite some way ahead of the competition. Now, of course, at the moment, SIAC is principally concerned, I think, with trade disputes rather than maritime, but they have reported that their maritime cases doubled last year. So they're on an upward trend. So I think my starting point would be that there is no room for complacency as far as our maritime arbitration offering goes. And I also think that competition is not a bad thing if it prompts us to review what we're offering and to improve it if necessary. So I think there are some ways in which the Act could be improved. I don't think anybody would suggest a root and branch reform because essentially it's a very good piece of legislation, but there are some wrinkles, if you like, that could be ironed out. I'll give you one example, and it relates to freezing injunctions. So one of the really important advantages of arbitrating here is that you can go to the commercial court and get a freezing injunction in support. And Section 44 of the Act is intended to give the court the same powers in support of arbitration as it has in relation to court proceedings. Now, in court proceedings, you can get a freezing order against a third party in certain circumstances, and that can be a very helpful and powerful tool. Unfortunately, because of the detailed wording of Section 44, the courts have been driven to the conclusion that that remedy is not available in support of arbitration. So that, I think, is unfortunate. And I think that is the sort of example that I would point to as being a case where we could improve the Act, iron out that little wrinkle, and improve the offering that we're providing to users of arbitration.
Excellent. Thank you, Karen. We've had a question as to whether arbitration can work in the context of shipbuilding contract disputes. Now, given the time constraints, I'll speak fairly briefly on this, but I'll answer that question because I've sat on a number of shipbuilding disputes under the LMAA terms over the years, and they are very widely used in shipbuilding contracts. And indeed, it raises an interesting point because when we use the term maritime, we use it in the widest possible sense. Maritime arbitration in London is not just about charter parties and bills of lading, although they are a very significant part of what we do. But we also deal with ship sale and purchase disputes, shipbuilding disputes, international trade and offshore energy, among other things. And indeed, the use of London arbitration in shipbuilding contracts has extended into offshore construction contracts, in my experience, too. So I've been involved in a number of cases on LMAA terms involving the construction or conversion of vessels for use offshore as specialist vessels, such as pipe laying, cable laying, and FPSOs and so on. But the short answer is the LMAA terms and London arbitration are commonly used in shipbuilding disputes. It is very common to have a mixed tribunal where there's some expertise in engineering and so on, which helps in determining tricky technical issues. But given the time constraints, I think the best thing is if anybody would like more detail on that, they'll find my contact details on the LMAA website, and they're very welcome to email me. It's quite a big topic, and there's lots that we could say about that. The other question that I have here is, other than the virtual hearings, what are the big upcoming trends in arbitration in London to ensure that it continues to meet the demands of users? Nick, do you have any thoughts on that?
Yes, David, thank you. Because the other side of arbitration is mediation, which is a very Asian thing, if you think about it. And mediation, of course, is really no more than a facilitated settlement negotiation. So it's helped along by an expert mediator. In the past, before COVID, when one talks of mediation, you imagine everybody camping over to London, sit around a room, and spend a day in negotiation using certain procedures. That is still true if you want to, but it is no longer necessary. So again, I myself have mediated a one-day mediation where both parties were in Asia. I, of course, had the pleasure of sitting at 2 a.m. in the morning, and we finished at about just before 1 p.m. And settled the case by WebEx, which is the Cisco version of Zoom. So that's one example of virtual mediation, which doesn't require parties to be present in London, physically present. That saves a lot of costs, obviously, and that is a great attraction. But other mediators, again myself included, have also evolved new methods of arbitration which don't require you to sit or concentrate everything in one day. So a mediator can shuttle like a diplomat between parties over the course of, say, an agreed period of time, say over a week, to try and persuade the parties to reach an agreement. So again, these things have all evolved with time. COVID brought everything together, but this telephone negotiation thing was already in place before COVID anyway. The main driver was saving costs. So that it seems to me is another big thing that is coming forward.
Thank you, Nick. Just before we finish, one final question. What can the LMAA do to improve their offering to parties based in Asia who want their dispute to be resolved more locally? I think there are a number of aspects to this. It's a very significant question. Of course, you can have an arbitration which is seated in London and the arbitrators can travel to sit elsewhere in the world, but I recognise that involves a cost that parties might not want to bear. We do have in our wider membership a number of potential arbitrators, people who accept appointments who are based in Asia and can be appointed, so they are local. And the other thing, of course, is that the use of virtual hearings assists tremendously in this because LMAA arbitrators have no difficulty in sitting at any time of day to assist in ensuring that the hearing takes place at a convenient time to people in other jurisdictions. So that's a brief answer, but again, if anybody would like more detail, please feel free to email me. Now, I'm afraid it's very interesting, and there are lots more questions I'd like to ask, but I'm afraid we've run out of time. So all that remains for me to do is to say thank you very much to our panelists, Karen, Sir Nigel and Nick. Thank you to the organisers at the Ministry of Justice and the Department for International Trade, particularly Megan and Duncan, who've been tremendously helpful. Thank you to the IDRC for these wonderful facilities. And thank you, our audience, for participating and listening. And we look forward to seeing you again soon. Thank you very much.